Welcome. Thank you, everyone. I'm Sean O'Brien of the Center for Civil and Human Rights, and on behalf of our director, Paulo Carroza, and our associate director, Chris Cervanek, it's my pleasure to welcome you all to the inaugural JSD conference, student conference, on new trends in Latin American constitutionalism. This conference is presented with the strong support of the Center for Civil and Human Rights and the critical co-sponsorship of the Kellogg Institute for International Studies and the Law School's program on constitutional structure. A special thank you is merited by the logistical and behind-the-scenes work of the Center's Kevin Fye and Jody Klontz for bringing our guests here, bringing you all here, and helping to make this event shine. As you can see by the program, and from the impressive background of our invited guests from across the hemisphere, and from the topics that these guests are set to sink their teeth into over the next 24 hours, this is not your average student conference. And that is because here at Notre Dame, we do not have average students. We have exceptional students, JD, LLM, and JSD students who together form an intimate international community engaged in the study of human rights and international law. For 40 years since our founding by Father Ted Hesburgh in 1973, the Center has supported this community of students and scholars as they engage on the most important human rights issues of the day and advance and explore a distinctively Catholic vision of human dignity. This conference was conceived and organized by 3 of those exceptional students who are currently enrolled in our JSD program in international human rights law. Soledad Bertelsen, a Chilean lawyer in her second year of studies, researches the role of domestic jurisdictions in the interpretation of international human rights instruments. Her dissertation focuses on the doctrine of the margin of appreciation in the European and the inter-American human rights systems. Pablo Gonzalez, a Mexican lawyer, also in his second year, researches the implementation of international human rights by municipal judiciaries. His dissertation focuses on the doctrine of conventionality control of the Inter-American Court of Human Rights. Pier Paolo Pigozzi, an Ecuadorian lawyer in the first year of his JSD studies, researches the transformation of Latin American tradition of human rights in light of recent constitutional modifications in the region. As a first-year JSD student, he'd probably be interested in any good dissertation topics that you can think of. Pierre, wave your hand. With these students and this ambitious set of research interests, it's no surprise that we are gathered here for a conference on human rights and constitutionalism in Latin America. In Latin America, constitutional change happens frequently to meet demands for the effective protection of human rights and the consolidation of democracy and the rule of law. As might be imagined in a region with such diverse social, political, and economic histories, this constitutional change has neither been uniform nor without tension between contrasting perspectives. This conference creates space for prominent scholars with sometimes divergent philosophical viewpoints to engage in a creative dialogue around issues of human rights and their constitutional protection. Our JSD students, as well as the 18 human rights lawyers from more than 15 countries in our LLM program, will be taking copious notes. For those of you not fleet of finger, I am pleased to announce that the papers presented in this conference will be published by the Notre Dame Journal of International and Comparative Law. The journal, now in its 3rd or 4th year, and fresh off their own fantastic symposium last month, is represented here today by several members of their board and staff. So thank you to you all from the journal for your participation and collaboration in this event. Our first panel this afternoon will focus on the protection of the individual within the context of a community.
That's the first panel.
That's my phone.
That's the first panel tomorrow, as I was saying. The first panel tonight is really more of an opening session that will set the table for the issues that will continue tomorrow including the aforementioned role of the individual in the context of the community. I think I was getting excited about that topic with today's anniversary of the 50th anniversary of Pacem in Terris and its reflections on the role of the individual in the context of the community. And so I was jumping ahead to that topic. Our first panelist is Professor Cesar Rodríguez Garavito, unless I stand corrected by the floor, who's a professor of law and founding director of the program on global justice and human rights at Universidad de los Andes in Colombia, and a founding member of the Center for Law, Justice, and Society de Justicia. He's a visiting professor this semester at Stanford Law School and has held visiting professorships at major universities and major human rights institutions around the world. He holds a PhD in sociology from the University of Wisconsin-Madison, an MA from NYU's Institute for Law and Society, an MA in philosophy from the Universidad Nacional de Colombia, and a JD from Universidad de los Andes in Colombia. That's a lot of graduation presents. His areas of research and publication include law and society, constitutional law, social movements, and globalization. Our other panelist on this opening session is Santiago Legarre, professor of law at the Pontificia Universidad Católica, Argentina. He holds a PhD in law from the Universidad de Buenos Aires, a master's from Oxford, and an LLB from the Pontificia Universidad Católica. He has been a visiting professor at several American universities, including Louisiana State, Valparaiso here in Indiana, and he's currently a warm and generous presence here at Notre Dame Law School. His research interests lie in the area of constitutional law and jurisprudence. Please join me in welcoming our first panel. Do you know if this first is right?
Good afternoon. I wanted to start by thanking the Center for Civil and Human Rights and the Católica Institute for the invitation. When I received the invitation from the group of students, really, I felt that I had to come here because this is my first time in Notre Dame, and Notre Dame has really interesting connections with Latin America that go back to the 1960s or even earlier, and I felt that as a Colombian academic, I had a special duty to be here today for two reasons. One, because the center has been a fantastic partner in a fellowship program that we have for Afro-Colombian promising lawyers. I run a project called Racial Discrimination Watch that sends off promising Afro-Colombian students to top LLM programs in the US. And the first time we did this program 3 years ago, we thought, well, where can we send these students that they could get top training, but also the kind of warm atmosphere, not warm precisely because of the outside weather, but because of the human warmth. And we thought of Notre Dame from the get-go. And immediately after that, I remember communicating with Sean 3 years ago. You guys understood the idea behind the project perfectly and have been exceptional partners since, and we've had the pleasure to send already 3 students to the LLM program. Sara Ferrer is here with us today. She's part of the second cohort, and really through this partnership we've been able to establish what should become in Colombia the seeds for the stronger presence of Afro-Colombian leaders and students in the legal academia and legal advocacy. So we're particularly thankful for that. But also, as a Colombian human rights scholar and advocate, we all know what Notre Dame did for people like Eduardo Pizarro and others, many others, who in the late 1990s had to go into exile. And they were warmly received here at Notre Dame at the Kellogg Institute, and they wrote and worked with local scholars, Scott Mainwaring, and many other people, Guillermo O'Donnell, of course. And because of that, basically, they continued their careers and were able to weather the particularly harsh times that Colombian academic political scientists were going through back then because of their commitment to human rights causes. So because of those reasons, and particularly, I'm glad to be here and thankful for the invitation. So I was asked to speak in this opening panel, and when I received the invitation, I decided to prepare an overview presentation as opposed to a presentation that focuses on a particular topic or issue. My colleagues, Roberto, Oscar, and many others, Agustin, and many others, are experts in specific areas and could also have given this talk. But since they're going to go deep into some details of socioeconomic right jurisprudence, on equality, individual liberties, and so on and so forth tomorrow, what I'll try to do is to give you an overview of what I think are literally, and that's my title, the trends, the innovations, and the dilemmas of Latin American constitutionalism over the last couple of decades. And of course, I have only 25 minutes or so, so I have to be very brief and on specific points, but I hope that at least it serves as an appetizer for what comes later today and tomorrow. So I'll begin with the trends part. And since it's late in the day, I thought I'd use this animation to keep you awake. And I'll do this through a little map that I'll use to give you an idea of the trends. So literally, this is a wave, and in a recent article I've spoken about this process of constitutional amendments and constitutional reforms and new constitutions coming out of different processes of democratization, of economic opening from the late 1980s through the present as a wave of new constitutional thinking and new constitutional institutions in Latin America. We could go back to earlier constitutions in the 1980s, but to start somewhere, this is the Brazilian Constitution in 1988, the Colombian Constitution of 1991, which has been quite influential in other constitutional courts in the region and also constitutional models around the region, the Paraguay Constitution of 1992, the Argentina Amendment of 1994, which included an expanded Bill of Rights, the Venezuela Constitution of 1999, the Ecuadorian Constitution of 2008 that I'll talk about a little bit more later on, then the Bolivian Constitution of 2009 that introduced interesting innovations like those in the Ecuadorian Constitution of multiculturalism and plurinationality. And finally, the recent amendment in Mexico in 2011. Mexico, which was sort of left out of this regional trend in 2001, incorporated an interesting amendment that we as scholars haven't, in Latin America at least, haven't taken very seriously, but I think it's worth examining with detail because it incorporated the expanded Bill of Rights that we have seen in other Latin American constitutions, including socioeconomic rights, and wholesale incorporations of international agreements into domestic human rights law. And the trends that I would highlight are three. The first one is the one that I was just commenting, the expansive Bill of Rights, meaning that in terms of Nancy Fraser's categorization of claims of justice, they try to tackle three things at the same time. And this is one of the substantive arguments that I'm going to make in the following part of my presentation. First one, issues of personal autonomy, individual liberties. Given that many of these constitutions, for example, the post-dictatorship constitutions of the late 1980s or early 1990s came on the heels of authoritarian governments, of course, the protection of individual liberties, civil rights, were at the heart of the new bills of rights of these constitutions that I briefly mentioned in going through the map. But the second issue that these bills of rights incorporated and that has been particularly innovated is the constitutional protection of socioeconomic rights, meaning that claims of redistribution in the most unequal region in the world were taken seriously, at least by the constitutional assemblies, and then later on by some constitutional courts. And finally, and importantly, issues of recognition, meaning collective rights, identity politics, have been turned into constitutional clauses that in turn have been enforced before the courts, with different varieties and at different speeds in different countries. But what I want to highlight here is the fact that this is sort of a three-legged animal, that in which, as I'll argue in a moment, some national creatures are standing on one foot, whereas others are trying to stand on the 3 feet with difficulties. But the key thing is that the expanded Bill of Rights incorporated the 3 generations of rights and were designed to address claims of justice coming from ideas on autonomy, redistribution, and recognition. Second one, quickly, is judicial review. And this is probably, you guys are familiar with this, so I won't elaborate too much. But of course, without specific enforcement mechanisms, the expansive Bill of Rights would have remained on paper. And they have remained on paper in many jurisdictions because of the lack of effective judicial enforcement mechanisms. So, for example, on the one hand, we have the tutela action in Colombia, which is quite open-ended, that's quite permeable to citizen demands, pretty informal, open to both professional and amateur litigators. And on the other hand, you have systems like the Chilean system, which makes a lot harder for citizens to resort to courts to enforce directly the constitutional rights that are enshrined in the Bills of Rights. And finally, one third trend that I would like to highlight is the internationalization of human rights, meaning 3 different processes. One, a process of diffusion, both from other regions and within Latin America. So we're starting to see both within academia and within jurisprudence, constitutional jurisprudence, a lot of internal diffusion, a lot of internal borrowing within Latin America, which is an encouraging trend. As I said, the Colombian Constitutional Court, for example, has been quoted quite a few times by other tribunals in the region. There's, of course, a lot of borrowing, and this is the second trend that I would like to highlight, regionalization. From the jurisprudence of the Inter-American Commission of Court of Human Rights and the recommendations and the reports from the Commission. So the fact that despite the recent backlash against the Commission, which unfortunately was not successful, there has been a constant process of incorporation, diffusion, and regionalization of human rights standards. And one specific recent area, which I have in mind because I'm working quite a bit on it, is indigenous people's rights. So the fact that the Inter-American Court of Human Rights decided cases like Saramaca, Sayamaxa, Yaqueaxa in Paraguay, more recently Sarayaku in Ecuador, has been crucial for national courts like the Colombian Constitutional Court to feel more comfortable in incorporating higher standards of enforceability of more vague international commitments like those contained in ILO Convention 169 on prior consultation. So that process, second process, it comes in addition to the process of internal diffusion. And finally, globalization, meaning that many constitutions have incorporated clauses that give some particular standing, legal standing, to international treaties on human rights. In the case of Colombia, Article 93 directly gives constitutional status to any international agreement on human rights ratified by the Colombian state. But more recently, as I mentioned, the Mexican 2011 constitutional amendment went in the same direction and actually holds out the prospect of graded application and enforcement of international human rights in Mexico thanks to that domestication of international human rights law. Moving on to innovations. In another piece, I've argued that Latin American constitutionalism has made quite a few contributions to global constitutionalism through these processes of regionalization, diffusion, internationalization, and particularly through decisions made by regional and national courts. And I'll just quickly highlight a few of them. One of them is, of course, the justiciability of socioeconomic rights. Just recently, I was going back to read the reports put out by Human Rights Watch in the 1990s, and even recently, a great book by Ariane Ayer that some of you may have read on the international movement, international human rights movement. Again, bring up this story of how major international human rights organizations were very much against the incorporation of socioeconomic rights into the work of the human rights organizations. And scholars such as Carl Sandstein, you may remember, were pretty antagonistic vis-a-vis the possibility that emerging countries, transitional countries like those in the eastern side of Europe or in Latin America incorporated socioeconomic rights, precisely because he saw that as a way to discredit the agenda of civil and political rights. If you have socioeconomic rights, which are harder to enforce than civil and political rights, which are costlier to enforce, and so on and so forth, goes the argument, then you might run the risk of overreaching, of trying to do too much at the same time, to the detriment of the enforcement of classical rights, like the right not to be tortured, the right to free expression, and so on and so forth. Well, after 20 years of these trends in Latin America, we have prevailed, so to speak, and I say we because I've been part of a large community of scholars and judges and advocates pushing for the enforcement of socioeconomic rights in courts. And we have, not only at the level of national courts, but also at the level of the Inter-American Human Rights Body, some inroads into the justiciability of socioeconomic rights. And I'll just mention one specific area in which this development has been particularly salient: healthcare. So in Brazil, there have been a number of studies that have shown how citizens have mobilized to use courts to make real the right to health that the administration, be it the federal administration or the state administration, have failed to fulfill. In the case of Colombia, again, more than 100,000 tutela actions, constitutional actions, have been brought before the courts every year that would have never gone anywhere in the state were it not because of the constitutional jurisprudence of the Constitutional Court that has opened up possibilities for claiming the right to health before the courts and lately before the government. So the level of litigation has gone to a point in which the state, and that has happened in Brazil as well, and the government and legislatures have felt the need to create new legislation that addresses the structural failings that have led to the massive litigations before the courts. So we can go into the details of the healthcare litigation later on in the Q&A, but the key thing here that I'd like to highlight is the fact that both at the theoretical, the doctrinal, and the practical level, the justiciability of socioeconomic rights has been an innovation coming from Latin America and many other jurisdictions in the global south, like South Africa and India, that have gone against the initial consensus in international human rights circles. Second one, the fact that some courts have been experimenting with what some authors like Roberto, myself, and others have called dialogic judicial activism, meaning varieties of activism that engage other branches of power and that try to bring in civil society actors into the enforcement of key constitutional rulings. And again, the case of healthcare is probably the clearest one, but I want to mention another decision by the Constitutional Court of Colombia on internally displaced people that has been has been going on for 10 years now. In 2004, the Constitutional Court of Colombia declared that the existence of more than 4 million internally displaced people, the human rights situation of those 4 to 5 million people, amounted to what it called an unconstitutional state of affairs. Meaning, basically in US procedural law terms, a structural injunction ordering the state and the Colombian government to do something, to put in place public policies that would address the structural failures behind the massive violation of human rights of internally displaced people. That has been going on for 10 years now, the follow-up process, pretty much along the lines of the Indian monitoring process, meaning monitoring the enforcement of the orders of the Constitutional Court. And in that process, the court, instead of just imposing its own preferences on public policy on the government, has chosen to elicit reports, proposals for solutions, proposals for legislation from the government, and importantly, information and input from civil society actors, from NGOs to victims associations, and so on and so forth. This type of dialogic judicial activism, I think, is particularly promising for addressing structural issues of inequality and human rights violations that are common in our region. Third, more quickly, because I'll focus on this in the last part of my presentation, multiculturalism. Of course, the 2008 Constitution in Ecuador and 2009 Bolivian Constitution are seen internationally sort of as at the forefront of the defense of the right to diversity. Now, sadly, in Ecuador at least, and to some extent in Bolivia, that has remained on paper because of reasons, political reasons, and also because of the fact that the emphasis on economic growth and socioeconomic rights, paradoxically, has been affirmed to the detriment of the defense of the rights of indigenous peoples and diversity, as I'll explain in a moment. And finally, on the realm of ideas, importantly, this wave of constitutional reforms and new constitutions has spurred the formation, the consolidation of networks, centers of researchers that are creating new constitutional thought in collaboration with each other. This is something that did not used to happen in Latin America, and it's happening a lot more. And many people have called this neo-constitutionalist thinking. Some people like that term, some others prefer other terms. But by neo-constitutionalism, I mean a variety of constitutional thinking that takes seriously at least these three other tenets of constitutional innovation. I can't go into the details, I'll just leave it open for discussion, but I can certainly give you examples and illustrations in the Q&A. And finally, I want to leave you with the dilemmas, because of course, so far I've sort of offered a rather optimistic, sort of rosy picture deliberately of the innovations and the trends, but of course there are lots of dilemmas. Some of them are expected, some of them are unexpected. There are some steps forward, some steps backward. The first one, and I'll sum up the first two challenges, the first two dilemmas, in terms of two isms. One of them was theorized by Guillermo O'Donnell, largely out of this campus, which has to do with the dilemma of creating a strong state, a strong executive, in order to speed up goals, the achievement of goals such as economic growth, but to the detriment and at the risk of individual liberties. And this is the phenomenon of presidentialism that O'Donnell and many others have theorized. Actually, O'Donnell at some point said that the presidentialism was that contribution of Latin American political science to international political science. And this we see in many countries around Latin America, and not just on the left, which are coming out of the bitter dispute over the reform of the Inter-American Commission of Human Rights, one thinks immediately of Ecuador or Venezuela or well, even Argentina with the government's fight against freedom of expression and some sectors of the media. But also in places like Colombia and Peru, we had this on the right as well. What we went through in Colombia during the Uribe administration was certainly a struggle between the sort of the consolidation of a strong state that would be able, according to President Uribe, to defeat the FARC and the insurgencies, at the cost of the suspension of massive violations of individual liberties. And the second ism that I would like to highlight here is very different in nature, which is the tension between the second and the third term in the triad of terms that I mentioned in the beginning of my presentation. So instead of being a tension between first-generation rights and second-generation rights, it's a tension between second-generation rights and third-generation rights, between claims for redistribution, socioeconomic rights, and claims for recognition, indigenous people's rights, environmental justice, and so on. And again, we see the conflation and the confusion of the frontiers between left and right here, because on the extractivism route, meaning whole economies that are riding high on the exploitation of natural resources, be it Peru, Brazil, Colombia, Guatemala, Venezuela, of course, has always gone down this road of economic development. What you see is that many of the key constitutional litigation and constitutional struggles are happening around the issue of extractivism, as many scholars of natural resource extraction call it. And this is exactly the type of conflict that we're seeing in the Sarayaku case in Ecuador, around the exploitation of oil in the Amazonian region. Likewise in Brazil, the Belo Monte case, the construction of what would be the third largest hydroelectric dam in the world, that was the cause of much dispute and loud protest of the Brazilian government against the cultural precautionary measures of the Inter-American Human Rights Commission last year. And we could go on with examples from around the country, and that's why, from around the region, and that's why this peculiar institution of prior consultation with indigenous people's rights has come to the forefront of national politics and national debates on constitutional law and constitutional adjudication throughout the region. Finally, I think I'm going to skip most of this. This comes from a paper I wrote on different approaches to this dilemma on redistribution versus recognition. I'll just go directly to the punchline here in the interest of time, because I'd rather highlight the final dilemmas that I have in the last slide. What I'll highlight here is the difference between two approaches to issues of multiculturalism that are evident in these cases and litigation on indigenous people's rights and prior consultation. So what we have here is, on the second column, is the version of multiculturalism that got incorporated in most Latin American constitutions in my initial map. Right? So, and I call it neoliberal multiculturalism because it means the recognition of diversity without the allocation of resources. What it means basically is that national constitutions went in the late 1980s and early 1990s from an all-out denial of the multicultural nature of national societies, which is the integrationist paradigm here on the column on the left, the old paradigm of assimilation of ILO Convention 107, to a more sort of enlightened but still shy approach to the recognition of indigenous peoples, right? They recognize diversity, the fact that there's cultural diversity, without attaching any material consequences and collective consequences to that recognition. Many courts in Latin America have interpreted ILO Convention 169 along those lines. More recently, for example, the Ecuadorian Constitutional Court, which has been very close to the Korea government, but also the Chilean courts and even the Bolivian courts have tended to understand, to incorporate sort of a low-intensity version of indigenous people's rights that hinge around the right of indigenous peoples to be consulted, but not of the right to consent to the exploitation of natural resources in their territories. And many of these cases, like the Santiago case, like many cases on mining in Peru recently, Conga and many others, and others in Bagua in the Amazon, have hinged around the tension between this approach, neoliberal constitutionalism, and what I call counter-hegemonic multiculturalism, borrowing from Boaventura de Sousa Santos, meaning a different understanding of collective rights, of indigenous people's rights, that raises the prospect of using the standard of consent, which the Inter-American Court of Human Rights has been using since the Saramaca case, and more recently again the Sarayaku case, through a more progressive understanding of ILO Convention 169 and the incorporation of the Declaration on Indigenous Peoples' Rights from 2007, the UN Declaration on Indigenous Peoples' Rights. So just to wrap up here, the idea is that the conflicts around, the disputes around extractivism are being waged before national courts and at the inter-American level around these two very different understandings of collective rights and the relationship to socioeconomic rights. And finally, I'll leave you with a few other dilemmas that are key, but I don't have time to elaborate. One is the issue of implementation. Of course, in Latin America, we have a lot of interest in literature, lots of fantastic judicial decisions on socioeconomic rights, but we have yet to tackle the challenge of implementing them. And of course, this is not just an issue for international courts, the issue of the implementation of progressive rulings. It's not just a matter of the Inter-American Court having trouble getting states to comply with their decisions, but it's also an issue within states. So the issue of implementation, how to turn those lofty declarations in the Constitution, or nowadays more at a lower level, at the constitutional court jurisprudence level, into actual practices and policies on the ground. The second one is one that Roberto will probably talk about tomorrow, is what he calls the asymmetry between the declarations of rights, the sophistication and the generosity of the declarations of the Bills of Rights on the one hand, and then the weaker and the less cultivated studies and also practices on how exactly to design institutions to put in place those rights. So it has to do with the issue of implementation, but it also has to do with an additional problem of institutional design. And the fact that we have this constitutional asymmetry in virtually every country, in which bills of rights are generous and sophisticated, and institutions to implement them via the legislatures, via the executive, are much more precarious, is a second dilemma that constitutional designs throughout Latin America are facing. The third dilemma that I wanted to highlight is the issue of unexpected effects. One of the innovations, meaning the justiciability of economic rights, has also created some side effects that are deleterious to the implementation and enforcement of human rights. For example, just give the example of litigation on healthcare, which I mentioned earlier in my presentation. Given that courts in Brazil, in Argentina, in Colombia have been so successful at getting the state to getting the governments mostly to comply with its obligations, with its constitutional international obligations on the right to health. Of course, citizen claims have flooded the courts with the unexpected outcome that the middle classes have been using litigation as a means to get even greater access to the courts than the working class. This has been happening in some regions, in some places in Colombia and in Brazil, not throughout the board, but it is common enough that this reverse redistribution from the working class to the middle class through the healthcare system via the courts creates some issues of equity and some issues of efficiency that are raising concerns among human rights scholars and activists in those countries. And finally, issues having to do, of course, with the rule of law. One of the paradoxes of this process that I've tried to paint here with very in broad strokes is that as we transitioned from the 1980s to the 1990s and then into the new century, the aspiration was that we would increasingly focus on second and third generation rights, because first generation rights were taken care of, right? After the experiences with autocratic governments and dictatorships, the idea was that the next frontier in human rights advocacy and scholarship would be second and third generation rights. And actually, when we founded the Justicia, this think tank that Sean mentioned in his presentation in Colombia, we established it to work only on socioeconomic rights, right? That was 10 years ago. And then came President Uribe and said, well, we again have these issues of basic civil liberties. We're back to the situation in which we have to go to the legislature to try to get to stop the government from packing the court, or from trying to co-opt the independent niches of the Colombian state, the ombudsman's office, the superintendents in different sectors of the state, so as to maintain the basic architectures of the rule of law. That is a troubling issue and an issue of key concern in places like Ecuador, Venezuela, Argentina, and many other places, not just Colombia. So again, we have this three-legged table in which we have to work at the same time on each of the three factors in this equation. I think I'll leave it at that, just to put the dilemmas on the table. I won't elaborate on them, and leave it for questions and discussion in the Q&A. Thank you.
Good afternoon. Thank you to all of you, especially to the organizers of the conference and to the members of the faculty of this law school present here today, and to some undergraduate students, friends who are also here today. It is really fantastic to speak after such a learned and expert presentation. One feels like a sense of deliverance and freedom. I more or less can talk about what I want to know, because Cesar here, whom I haven't had the pleasure to meet, but I'll say hello now, has done such a great job. Let me share with you, as a bit of reconstruction of history, how I experienced that this conference happened to exist, and therefore for us to be here today. So I don't know if it has happened to you when you write an academic article, or perhaps even an otherwise article, that you wonder whether someone is ever going to read it or to react to it, or whether it's going to have any consequence, dramatic or not so much. And you find many times that nothing absolutely happens. So sometimes you decide that you will send it to a group of your friends, and you also find that nothing absolutely happens many times. So sometimes you may decide to send it individually to a person. Now that's what I did exactly a year ago, the day I met Paolo Carrozza. So I sent him an article on comparative constitutional law and the universality of human rights. And that did have a consequence, and one could say that perhaps the inception of this conference was that consequence, because 5 minutes after I sent it, he was in my office here at Notre Dame Law School saying, why don't we put a conference? Why don't we ask the SJD students, who are actually now the real producers, and as it appears to be the total cause of this effect, but now you know the whole of the truth that they know as well. So we got together, Pablo, Pierre, and Soledad, and Paolo, and perhaps someone else, I don't remember now, perhaps Sean was there, here at the center, and we started to discuss this. It took quite a while. Then, through their effort, to which I'm very grateful, this happened, and here we are. So it's worth writing, but you need to send an email, and you need to find an Italian or American Italian friend who will read it. The article indeed has much to do with new trends in Latin American constitutional law, because, as explained by Professor Rodríguez Garavito, I find it so weird to be speaking in English and pronouncing the name Rodríguez, knowing that half of the audience is Spanish-speaking, said, diffusion, he said, and borrowing are some of those trends, and that has, of course, a lot to do with the phenomenon of comparative constitutional law. So in that paper was the result of an inquiry about the question, does it make sense to borrow? Does it make sense to compare? And I had this intuition that it only made sense if there was something real in common between the terms of the comparison, the peoples whose laws are being considered with a view to compare. So the conclusion after an argument there was that it only makes sense to diffuse, to borrow, to compare if there is a common truth that we can seek, a truth about which we can converse, including in legislation and in jurisdictional dialogues. Otherwise, why waste the time? That's not the topic of this talk. I don't know what the topic of this talk is, but that's not it. So I'll move a bit along the lines of the relevance of this notion of a shared truth, accessible to human understanding. This notion, I think, is yet again important when we think of the role of the law in our Latin American society. So not only is it important for comparative constitutional law, it's also important to understand the law itself in our societies. For, as Rabbi Bergman of Argentina put it, and I quote more or less because it's in English, I resort to the law when my non-legal friendly mechanisms have been exhausted. So the law as a more or less last resort, not the criminal law, the law, which I took to have something in common with the idea expressed by a famous English judge when he said that, I quote, "Society is more than people living in proximity to one another in a state of peace." So, society here, of course, well, I was dealing with this notion, and in the class I finished teaching yesterday. I was going to say I'm teaching, but I need to realize that now I'm going to Argentina. So my students here, they didn't understand the word society in this phrase by Patrick Devlin. So I had to explain that society here is akin to nation or to country or to a community. That's what he means when he says that society is more than that mere legal coexistence. In other words, a people, a society, is more than their laws. That's the notion behind Devlin's statement that it's part of an otherwise totally flawed theory, in my view, but that's, again, part of another talk. So I think this is important when one confronts the reality of our Latin American countries, where having left behind years of dictatorships, they are now by and large under democratic regimes. One still thinks that, or at least I do, that there is a significant democratic deficit there. And when I say I do, I must here make an honest disclosure. When I started preparing this talk a few weeks ago, I really didn't know in what direction where to head. So I met with Pierre and Soledad, two of the organizers. Pablo probably wasn't at hand. And they gave me some really great ideas. And actually what I'm going to say now is partly theirs. You know, the typical caveat would add that all mistakes are mine, but I'm even tempted to say that I took so much from them that if there is any flaw here, maybe we should look at them. You were spared. So what are those deficits? For example, violations of human rights. For example, as I see it in my country, an evident lack of independence of the judiciary in some relevant situations in which it is severely under pressure, or as we can also see in Venezuela, for example, with the government of the late President Chavez, where you had even cases that reached the court in Costa Rica about judges being under pressure, being licensed before their time, removed, etc. Then, of course, you have the problem of inequality, a problem that is still very much present, as it was said by Professor Rodríguez Garavito. I always remember Cardinal Bergoglio, now Pope Francis, saying, but this was said by the church even before him, that in Argentina, los ricos cada vez son más ricos y los pobres cada vez son más pobres. Now, should I translate that? Probably not, but I will. So the rich are increasingly richer and the poor are increasingly poor. It's so clear in my country that the rich are increasingly rich. That's totally clear. And the same is true about the poor, unfortunately. So how do we do? These are just simply three examples: violation of human rights, lack of independence of the judiciary, inequality. Other examples, dilemmas were correctly identified before and in more detail. How do we deal with this at a general meta-theoretical level? How do we do to identify the changes that are necessary to bring about the remedies to these problems and other similar problems. My point here will be that however we do it, it is first important to keep in mind that we will always need to identify what is really good for those peoples we're talking about, which presupposes my ability to know what is good for those people. I was talking the other day again to my friend Carrozza, and he was sharing with me his experience of when he taught in Harvard as a visiting professor a couple of years ago, and having conversations with many students that clearly showed that they underestimated their own capacity to understand what is good, what is bad, what is better, what is worse, what is right, what is wrong. Like they declared themselves agnostics about these things. Now, if as a legislator, as a reformer, as a constitutional reformer, I am also agnostic regarding these, then my people are simply going to be at the expense of my whim, because that's the only thing I will have to offer them. I won't be able to offer them reasons because I won't believe in the ability of my reason to begin with. As Professor Finnis put it, the question is, and I quote, "What elements of individual and societal makeup are presupposed by political institutions capable of upholding justice and freedom?" Now, makeup here, it's one word. I had no idea what it was. I sort of guessed that it didn't have to do with women and makeup. So I emailed him, and he was gracious enough to supplement 3 alternatives for makeup. So I'll use one of them, and I'll substitute it as I read another quote from Finnis in the same paper. This is a paper he wrote on H.L.A. Hart, published in his collected essays and in the American Journal of Jurisprudence 2009. The answer to the question how to identify what to do to remedy the problems, the answer, I quote, will involve attention to human needs, opportunities, and structure makeup. Human needs, opportunities, and makeup structure, both individual and social, to biological, physical, psychological realities, and to spiritual possibilities. Now, this is me here, so here I get all the credit, and I risk to lose everything. If, for instance, someone proposes X, a critical moral response to X can uphold Y as a superior position in realism about human character, opportunity, and fulfillment. I'm paraphrasing what Finnis had just said. Of course, the proponents of Y will need to argue for Y. They will need to prove that Y is right and X is wrong, or depending on what we're talking about, that Y is better than X, all things considered. Because of course there are some things that are not right or wrong. Indeed, the question of what is really for the common good, so that really has to do with the ability of the Harvard student to know the reality. We don't have that problem at Notre Dame. The question of what is really for the common good of a society, of a community, of a nation, is necessary too for the criticism of the present institutions, insofar as we claim that they deviate from that common good. It is also necessary for the assessment of those institutions that are candidates to replace the ones that we say are flawed. Without such moral perspective, one that keeps an eye open for what is really good, and is hopeful that what is really good can be the object of some relevant knowledge, Without that, it is hardly possible to measure which social experimentation is successful and which one is not in the relevant sense of successful. So this is Soledad's idea here. Experimentation in itself does not guarantee a perfect society. So if you like this, you can, and if you don't, you go to her as well. This type of approach, open to the truth in practical matters, will allow us, I think, to navigate promising waters, leaving aside extreme ideological positions both from the right and from the left. For example, and I quote Finis again, a liberalism that consciously evades material moral issues as controversial or non-neutral is prone, indeed, to evade essential facts, causalities, interdependencies, and the like, even when these tend to determine outcomes fundamentally. At the same time, this is me, a perspective open to the truth will allow us to protect the cultural patrimony or heritage of our peoples without falling into relativistic multiculturalism, which is one type only of multiculturalism. For example, this point of view will allow us to distinguish different practices in different countries. So I spent 1 month in Bolivia, near La Paz, last January, and also the January before last January. And I had the opportunity of talking at length with a lady who worked at a little shop outside the zoo of La Paz. And she was telling me very proud how she had witnessed a few weeks ago the crucifixion and simultaneous burning of a thief because they have this custom, which is apparently very efficient, of either hanging or burning or crucifying thieves. And you see all sorts of signs of this, like in the corners you would see a hanged man. I mean, it's a puppet, but it says this is what we do to thieves here. And I mean, and of course it's like you see it and you're like, what is this? And at the same time, it's not that easy because the judicial system doesn't work well, people are poor. So how do you assess this? Is this situation similar from a moral point of view to the situation I witnessed also in Bolivia of Don Marcelino? This was Dora, the woman. The man is Don Marcelino. He's a gardener whom I met working on a Sunday at his fruit garden. He sells his fruit. And I said, so, you're working on a Sunday? And he says, what do you mean? What do you mean? What is a Sunday? So he works every single day of the year. It's a culture practice altogether different from mine. And the two examples here I only provided without giving any conclusive judgment to say that these are two different things when it comes to the idea of what does the law do with one and with the other. In some, borrowing from Föderlin in 1952, it is crucial to avoid what he called the inclination or mood, and I quote, to disregard the structure of reality, a blindness to obvious dangers and a reluctance to meet them with all seriousness. I move now to a different, briefer, and connected issue. As I see it, one of the salient, forever lingering structural problems of Latin American countries, perhaps with some exceptions, is the insufficient respect for the law and for the laws. So let me tell you a story that perhaps may serve to illustrate the point. I take lessons of German in Argentina, and I become very good friends with an old man. He's 83 years old, and we are neighbors. So we take the metro, the subway together, and then we walk 5 blocks to our respective homes that are 1 block away of each other. And I realized after doing this a few times that my friend Marcelo didn't care much for traffic lights. He simply looked, I mean, he's 83. He simply looked, if there wasn't a car coming, he would cross. Never mind if it's red, if it's green, irrelevant. So one day, I mean, he studied at the MIT. He has, 2 PhDs. He's a very educated person and very Argentine with a German name, but Argentine. So I said, Marcelo, what about the traffic lights? I mean, we might get killed once with just this attitude of yours. And he goes, Santiago, rules are for the guidance of the intelligent and for the abidance of the fools. Now, we had problems with the word abidance. I was asking Sean a few minutes ago what the noun is for the verb to abide. Now, given that no one laughed, it may be that perhaps it's not abidance. Is it, Barry?
Abide.
It is? Good. Well, then maybe it's not such a good joke. It wasn't a joke, actually. The idea behind that is that only stupid people abide by the law. The smart people, they use them as standards and they do whatever is best in each situation. That summarizes Argentine heart and soul. And maybe not only Argentine, but perhaps not Chilean. The judge here will enlighten us. So when it comes to constitutional reform and constitutional amendments, the problem of the lack of respect for laws that my friend Marcelo's example sought to illustrate is quite dramatic. Take again the example of Argentina. In 1994, we had a man, Carlos Menem. He was the president and he wanted to run again for the presidency, but in Argentina, the constitution didn't allow for this. So we underwent a constitutional reform that had only one true reason, and that was the will of Menem to be re-elected, and I must say to the will of many people to vote him, which is like my friend Marcelo would be perhaps could explain why there are so many people say, well, we're going well, the rules, they don't care. So now apparently it was the case, maybe it is the case, I don't know, that our present president also wanted to get a third re-election. Now the second there is already, and it was introduced because of Menem's whim and the people's vote. But now apparently she wants to go for a third one, which Menem also tried. Maybe she won't, that doesn't matter, but I think this is very sad. It is very sad. And if this sadness continues to exist, like my very humble advice would be, well, if you are going to do it because you have the power and you don't care about reasons, well, don't touch the rest of the Constitution. Not even in 94, not even now. If that is a reason, just touch only the little article to avoid all the subsequent mess. All this is the antipodes of the famous dictum, a government of laws and not of men, included in the last article of the Bill of Rights of the Constitution of Massachusetts, 1780, which I think is somewhere in the campus of Harvard Law School, but I asked J. Titmarsh and we couldn't find where it is in Harvard, so I decided I wouldn't include that in the talk, although I suppose now I did. Well, Finally, my view is that the problem of the lack of respect for the law in our countries, certainly in my country, is an instance of a broader problem. Now, this broader problem I will illustrate with another story. I hope I'll go better with this one and I won't use any controversial verbs and perhaps someone will laugh, at least out of sympathy. So when I arrived in England in 2002, on one occasion, some friends were watching the first Harry Potter movie on TV, on a pirate video. Had just been released. I hadn't read any of the books, and I thought wrongly that I wouldn't read any of the books. So I decided I would watch the movie. Now, there's one thing I remember about the movie, and it is very relevant for you if you want to learn something from today. And that is when Professor Severus Snape is introduced to Mr. Harry Potter, our new celebrity, as he says. So Snape tells Harry the story of Harry's father. I believe he was called James. And tells Harry that James had a certain disregard for the rules. Well, I suppose that at least for Argentines, that certain is somewhat of an understatement, but that is exactly the idea I'm talking about. And I guess that for those of you who live in this country, you want to know that there is an important difference, cultural difference, between the attitude here and there, maybe with one exception. So in 2003, I taught for the first time in the US at LSU, and I told this very same story of Harry Potter to try to explain Argentina. You know how professors are, we say the same all the time. And the students said, well, this is exactly Louisiana, a certain disregard for the rules. There's no difference between Argentina. I mean, we have governors in jail, etc. Well, let's imagine that Louisiana is French for a moment, or was French, or Spanish perhaps. The US is different, and it's culturally different. So the problem of the laws is a cultural problem. Is a problem that perhaps has to do with our roots in our Latin American countries. Spanish roots in some of the countries, Italian roots in some of the countries, like in Argentina. I hope that Professors Gargarella and Carrozza, both with Italian blood, won't quarrel me if I share with you yet another story with which I will close my talk today, and that is that when last year I went back from Nairobi, where I had been teaching a class, exactly the same class I've been teaching here now. I went to Italy, not to Argentina. I went to Lecce for a wedding, and they were asking me about Africa in Lecce, and they said, did you know that Africa starts in Rome? That from Rome southwards, it's Africa? What do you mean? Well, for example, they said, in Milano, in the north, traffic lights are regulative. In Rome, they are orientative. And in Lecce, they are decorative. Like for my friend Marcelo, they are decorative. So, and I finish with this, they are not a guidance. Marcelo said, my friend, they are the guidance for the intelligent, and they are for the abidance of the fools. They are not even guidelines. So in Nairobi, for example, it's very important to take it seriously that traffic lights are not for guidance. They are not mandatory. They are not orientative. They are decorative. So you need to do what the guy who is there says. The lights will say red, they will say green, but that's for the colors. Maybe it's nice to have colors. When everything moves, you move. When everything stops, you stop. Unfortunately, in some aspects, that is the reality of my country and of some Latin American countries. Hopefully, tomorrow we'll gather some good ideas to try to get things better. Thank you.
Yes, we can open. We will have 10 minutes for
About
questions.
10 minutes for questions for our cocktails ready. So questions, let me start here.
One question for each. Thanks, Cesar, for the wonderful presentation. Just one point about what you said about the institutionalization. I don't think it's so much that we develop a lot of sophisticated ideas on rights and social rights and non-sophisticated approach to the organization of power. I think it's something stronger, which is that I mean, to put it graphically, we have like 21st century Bill of Rights and an 18th century organization of power. So, and that's there, and that's not because of lack of attention, but it's because of a decision, and that's a decision that puts rights into risk. So that would be important. So just to emphasize that it's stronger than what you say. It's not just that we didn't reflect enough, but it's that there was a decision to keep 18th century type of organization of power, no? Like in the same way that you said, that presidentially, hyper-presidentially, etc. Santiago, I think you touch an interesting issue that maybe you want to elaborate a little bit more, which is about the importance of having a common conception of the good, and so I think there is something to think about, whether it's not enough, for example, to respect human rights, to take autonomy, dignity, and the harm principle seriously, that we also need to have something like a shared common understanding of the good.
Thank you.
Response from the floor before.
Yeah. Well,
Do we take multiple
there's,
questions?
there's not much time, so let's take a bunch of questions and then.
Santiago and Cesar, I will also make two questions. First to Santiago, I was kind of surprised with your description of the unrule of law in the continent, and with a very culturalist base, because we are Spaniards or we are Italians or Portuguese, you didn't even remember Portuguese, which are very law-abiding people, by the way. I was surprised in both terms when you gave the example of Italy. I remember the Operazione Moni Puliti, the great scandal in Italy. The heart of the scandal of corruption and unrule of law was in Milan, not in Sicilia. If you take, you gave the example of Alabama, but you, of Louisiana, but you could give of Alabama, where things happen in the same or in the worst way. So, should we really tackle this idea that the disrespect for the law is a matter of cultural heritage, or perhaps there are other motives, like social and economic structure, inequality, which by coincidence, the continent, Latin America, is the most unequal continent in the whole world. So perhaps there are other, I'm not saying that there's no cultural drive, but I'm saying that perhaps there are other issues or institutionalization that we should take into account. So that's my provocative question. And Cesar, I liked a lot your presentation, and most of all, and I'm sorry that you didn't have time to explore, of the dilemmas. You know, what went wrong? Because you know, we are very enthusiastic about parts of this new constitutional trends. And one of the things you said was perhaps that this new institutional engineering left behind some old 19th century problems. Just to keep in the same point that I made to Santiago, is the rule of law. You know, if you say police reform, judicial reform, it didn't really went well in terms of changing the pattern of behavior of arbitrary use of force. So if you have time to explore a little bit, if this is in a context with some competition, so if there was a necessity to keep in weak states arbitrary law enforcement agents to overcome its own weakness. So it's a paradoxical situation. So if, in Colombia and in Mexico and in Brazil, which happens more or less the same time.
We have more time than I thought, so why don't you go ahead?
It is just a short question, quite related to the...
Excellent.
It's for Professor Garavito. From your picture, I have the impression that politics is being expropriated from the parliament, executive, and going to the courts. The longer are the Bill of Rights, the more sophisticated are your Bill of Rights in Colombia, Brazil, Argentina. Do you think it's better for politics than democracy? And I mean, we are locating politics within a non-democratic organization, the judiciary, the courts. That's my question, because I missed the role of the democracy and the organization of Congress in Latin America.
And with that, we can open it to the panel, and then we'll have another round of questions. Thank you.
Okay, so I'll tackle the first two questions together. I agree with Roberto, and it's a matter of both the enactment of the Constitution, meaning that there are some issues that were left unresolved or were resolved unsuccessfully in those 19th century types institutions that were left inside the Constitution, same constitutions that include the General Bills of Rights. So I would agree with that, including, for example, representation of the opposition, checks and balances, guarantees for the independence of the judiciary, you name it. Now, I think there's the dilemma that Oscar raises here is at the heart of the problem, because it's really a conundrum. And I'm going to use, given that it was Oscar who raised this issue, this idea by another US Brazilian scholar that we've discussed with Oscar, Roberto Mangabeira, right, whose theory was always that you need a strong government, right, in order to expedite change and in order to bring about not just economic development, because that we knew, right, that's the developmental state. So Hirschman and others already thought about that, the CEPAL, the ECLAC, theorized this in the 1950s, 1960s. And then you get states like the Brazilian contemporary state. And on the other hand, you have demands for the strengthening of the state coming from the citizenry sometimes from business sectors because of the lack of public order. So that's the case in Mexico and Colombia these days. Right? So on the one hand, you have demands for economic growth and development, and you get the type of strong government, the type of Argentina and Venezuela and Brazil. You know, very different governments, but in this respect, in respect of having a strong engine of growth, that's the developmental state. On the other hand, you have requests and the demands for the strengthening of the state vis-a-vis competitors. The guerrillas, the paramilitary units in places like Mexico and Colombia. And usually these arguments are crafted in sequential terms. What they would argue is that you first have to have a strong state to take care of the socioeconomic rights. And then you take care of the other issues, and even if in the process you have to sacrifice some individual liberties, so be it. That's the cost of development. It's actually a very old argument. And so I think there is an intrinsic dilemma. Of course, people like me and many of us who believe both in civil liberties and socioeconomic rights don't buy the trade-off, right? But certainly that's very current. Just to give you an example, I'm sorry to resort back to this issue once and again, the issue, because it's in my mind, still fresh in my mind, what Venezuela and Ecuador, Bolivia, and Nicaragua would argue vis-a-vis the Inter-American Human Rights Commission is that the Inter-American Human Rights Commission pays too much attention to civil and political rights and it goes after these governments opposed to socioeconomic rights, right? And that's why they don't give a hard time to other countries in the region who do not have the type of social policies that they have. So, with regards to Unger, what we got was sort of the outcome that he wanted, but with that also with the risks that he did not anticipate. And I would argue that in the particular case of Brazil and in other visible cases like Ecuador, the issue is that economic growth and socioeconomic policy really have taken such central stage that, especially in places like in Ecuador, the government is willing to brush aside considerations for individual liberties and civil and political rights, which are and likewise in Argentina, although Argentina is such an ambiguous case, that I wouldn't dare make such strong statements there. But that's why I said that we're back to square one on the rule of law. So litigating and theorizing issues like freedom of the press, judicial independence, and so on and so forth. So that's the type of it. But I think I don't have a definitive answer for that. It's an intrinsic dilemma in the type of state that has taken hold in many countries, that is strong on the development side and social policy side, but strong also for crushing individual liberties and going after those liberties. And with regards to politics, very briefly, I actually think, well, this of course is a classic debate. It will take a long time to do justice to that debate. But my answer would be that we're already at that third moment in that debate. So the first moment was the long period of formalism, right? That there was took hold in Latin America throughout the 19th century and most of the 20th century, in which any intervention by courts in high visibility human rights issues, even civil and political rights, but mostly definitely socioeconomic rights cases, would be seen as an intervention in politics, right? And then the counter argument came from the anti-formalists and from the reformers and the ones who introduced those generous human rights bills in the constitutions alongside with enforcement mechanisms, right? Meaning that sometimes the argument takes this form. Well, the government is not doing anything, so if anyone does anything, well, welcome, right? So if the courts are able to end the stalemate in the policy process, well, that's a benefit for democracy. I think that argument went too far, and I was among the people who made the argument for the intervention of the courts in issues of socioeconomic rights. When taken to its extreme, it means forms of intervention that may impinge upon the competence and the purview of the legislature and the executive. And that's why I think we're at a third stage of that debate, which I mentioned has been couched in terms of dialogic judicial activism, in which, through thinking about the remedies, through thinking not just about the content of the decisions, but also about how precisely courts intervene, how their remedies are written, are crafted, and how the follow-up process are implemented, then we can have democracy-enhancing court interventions that are somewhere between the traditional formalist judicial pacifism and the hyper-activism that was defended by some of the reformers in these amendments and new constitutions.
I will take advantage of Roberto's remark. I take it wasn't a question to share with the audience that when Professor Rodríguez Garavito referred several times to Roberto, this is Roberto Gargarella here, my colleague, one of the finest constitutional scholars in Argentina. And perhaps my mentioning that a couple of governors of Louisiana had been in prison, perhaps it was that prompted our disagreement, in which case I think it will be easy, but otherwise we will remain in disagreement, because my point is not about organized crime as in Milano or Mani Pulite or the governor of Louisiana. It's a more general thing that can be summed up by the definition of a gentleman. Now, there are many, but I like one that I learned once having breakfast in Oxford, and that is that a gentleman is a person who will use the butter knife even when he's alone. That is, that little knife to take the butter to your own plate and then use your knife so that you don't mix the jam with the batter. So if no one is looking at him, he will still use the butter knife, which is of course ridiculous because you're mixing your own things for yourself. Well, that's the thing. That's the attitude toward rules, pervading cultural one that we don't have in my country and some other countries, and that I think, but it's of course impossible to prove it, that would not change with social or economic changes or institutional changes. It might change with education, perhaps. I don't know.
You had the next question.
Yeah, my name is Garavito. I come from Ecuador. I used to work for the government for 3 years in the process of legal implementation of the Constitution. So my work, my question is, because I was there and I know how all this process of implementing the new reforms of Ecuador took place. So my question is for Professor Rodríguez Garavito. I was quite surprised that you decided to take the word multiculturalism as a trend, when actually the constitutions of Ecuador and Bolivia envision the notion of a plurinational state, and it was definitely very clear that plurinationalism was the proposal of indigenous political movements in opposition to the neoliberal multiculturalism of the 90s. And I guess that the first answer to them was not necessarily as the discourse of rights according to what is plurinationalism. I mean, not only in terms of rights, of indigenous rights, but about indigenous power. And I guess that there's a lot of political scientists now who are identifying Bolivia and Ecuador as places where there are new trends toward creating new mechanisms of participatory democracy. And this is the way how plurinationalism can be understood. However, when you refer to these changes, you still use the word multiculturalism, and you still find the government principle in self-determination without actually, giving an explanation of all these democratic changes. And I think also that, yes, what you said is right about Correa and what is going on with indigenous peoples, but I guess that the other part of the story that sometimes people doesn't know is that, well, maybe yes, in Ecuador there's a problem now about politics and law, and I guess that that's not a problem just of Ecuador. I mean, it's everywhere. The problem of the gap between reality and what is written is a problem of, I guess, every legal system. But the thing is that I guess that also what is happening is that indigenous peoples are part of the government now. I mean, this story of, in Correa as opposed to indigenous peoples or indigenous human rights activists is completely true, and I know that. I know, and it's very criticizable. However, the other part is that a lot of indigenous peoples are also part now of the power, and they are creating a lot of all these socioeconomic policies, and this is how I see some kind of change in multiculturalism now, of the politics of representation of indigenous peoples. It has completely changed. And I think that in Bolivia is radically different and completely much more representation of indigenous. So I wanted to know what is your reaction to this.
Well, thank you. Thanks to both of you for two wonderful presentations to get us started, both for the richness of what you included and also for the very different styles of presentation, which I think are a provocation to us to be very broad in our understanding of what we're doing over the next day. So I have a few interrelated questions. I'll try to be as brief as possible and not directed at either one of you in particular, but one starting point that, despite their divergences of sort of, style and orientation of starting ideas, that in this strange way were kind of similar, I thought I was struck by the diversity of what's going on in the constitutional space. Each of you, in different ways, emphasized a lot of different things going on, many of which, it strikes me, are quite contradictory to one another. I mean, we could go through the list and point out how, some of the emphasis on judicial supremacy is quite contrary to a dialogic approach to constitutional structures, and some of the openness to internationalism and regionalism is quite distinct from the kind of approaches to plurinationalism and indigenous people, so, and on down the list. And so I wonder, and equally, the social basis for law that was emphasized in all of Santiago's remarks, it was implicit in it was an emphasis that the peoples are different, and that's relevant to this discussion. So I wonder whether it is in fact reasonable to be talking about a trend in Latin American constitutionalism at all here, or whether really the only trend that we're talking about is that we're in a period of constitutional ferment. And that's really all there is to it. There's a lot going on, and there's a lot going on across the whole region. And that's what the commonality is. But then, the second part of the question, there is something else that then struck me that maybe is going on in common, which is there seems to be a real convergence around an implicit idea of using public law and constitutional law as a fairly radical agent of social change to address fundamental problems that have been deeply rooted for long periods of time, widespread problems in the region, endemic problems of social exclusion, of lack of institutionality, of poverty and equality, and so forth. So is that really then what the unifying factor is when we're talking about this, the trend in constitutionalism? It is really a trend in seeking ways to use constitutionalism as a tool of social engineering. Third part of the question then. Is this a new version of the law and development movement of the 1960s? It's just one that really, however, moves more towards public law and constitutional law rather than the law and development of private law and business and the rule of law and all the rest that came through the 1960s. But, and now the last part of the question, which then incorporates Santiago's comments most explicitly, if it is, what is the relevance of whether and to what extent we have a prior social reality that is expressive of new kinds of approaches to law, on the one hand, or do we have a movement that is in fact not so autochthonous from a social point of view, but is trying to import or construct certain kinds of legal and constitutional changes against the background of a social reality that is quite, where there's a significant gap between the law and the society, and that's what's going on. Is there a social basis for what's going on in terms of constitutional changes, or is that in fact the object of the constitutional change? Excuse me?
So you get to pick your answers here to these questions because we have 2 minutes. So.
Oh, sorry. A lot of this stuff we'll talk about tomorrow.
Okay, so thank you for those questions, which are both Well, you asked like 5 different questions. It's all very hard.
Oh, no, it's just one.
No, but no, thank you for those questions, really. So quickly, on the diversity and contradiction of trends, I think that's correct, and that's partly what I wanted to do in offering sort of a menu of different trends. Although I did try to sneak in the idea of the regional trends because I was asked to, but as an opening session, and it has worked as an opening presentation, and I said, well, there's a lot of things going on, and you go figure out what they are. But I think you touched upon one issue, Paulo, that I think is key, and I would agree with that. The fact that there is a renewed faith interest in using public law as an instrument for radical social change. And what's radical depends on the political context. It's very different than what the Chilean legal community would understand as radical change from what the Venezuelan or the Ecuadorian or for the matter the Colombian, Argentinian or the Brazilian legal community would understand as radical change. But definitely the use of law and courts in some, and not always, in some places like Colombia and Argentina, courts are part of the equation, but in many others, for example, Ecuador, it's mostly through the executive and now the legislature, because the executive and the legislature are working together a lot. So whether that resembles the law and development paradigm, I think it's a great question. I think there are some commonalities, definitely. The idea of a strong state, this idea that Oscar was raising, of having the state being the engine of the developmental project, definitely resembles from the modernization theory in the 1960s, all those four-funded projects from the 1960s, 1970s. Now, with a twist, because in Brazil and many other places, well, we've already had the neoliberal revolution, so to speak. Thatcher just died, and she was pretty influential in the 1980s, 1990s. So the lawyers, I don't think, are no longer in the driver's seat. They're part of multidisciplinary technocracies in which economists and economic ideas are paramount. So the local versions of law and economics have clashed against local versions of anti-formalism and social democratic legal projects. And I wrote an article in which I characterized this as the clash between neoliberal legalism and neo-constitutionalism. Of course, different manifestations in different countries, but we don't have time to go into the details. I'll just leave it at that. Yeah, definitely some resemblances, and definitely and a renewed interest in laws and instruments.
And Professor, I'd ask that you follow up with her during the reception, so that Santiago can have the last word.
It won't be the last word, though. But do I know whether there is a social basis or whether this is an imposition? I don't know. But I don't know enough to answer that question. But this much I will say. I get the impression that there are in our societies elite groups, especially of lawyers, that come to study, especially to the United States and especially to some universities, that bring ideas that are in a way artificial, very much so. But this happened before in Argentina. It was an elite class, for example, in Argentina 200 years ago, the one that got us moving and so on and so forth. So is it bad what's that now Yale controls in Argentina? Maybe it is bad, but I'm not sure it is bad.
If it's Yale, it is.
Exactly, that's my point, and that's how I finish. I'm not so worried about the fact that they are elites. I am more worried about what they bring to us.
Excellent. Thank you. With that, we thank the panel. And we'll see you again tomorrow morning at 8:30.
I couldn't resist.
nodded and said follow up. Thanks for
Ocuparon los españoles hace rato.